talking about everything that's happened this year. This event helps us to mirror everything that's happened, look back, reflect on everything that's happened this year, and then make predictions for the coming year. So what do we hope to see in the coming year, or how do we foresee next year to be, right? So I'm not going to go ahead of myself to simply just let our speakers talk about themselves and everything that has happened this year. But before I go on, I'd like to tell you about our partners, because we appreciate our partners. We wouldn't have had this event without our partners. So the first partner, of course, the event is organized by Tech Hive Advisory. So Tech Hive Advisory is one that has put everything together with collaboration from our partners. And we had support from the Tanzania Private Professionals Association, which is a community of privacy professionals. We couldn't have a representative on the call to speak with us today, but then the audience has people from this community, and of course our reflections are also going to look at Tanzania, everything that's happened in Tanzania as well, because it's a part of Africa. Then another partner is Privacy Lens Africa. Privacy Lens Africa is a research organization that focuses on discussing trends on data protection in Africa. So you must have seen research from Privacy Lens Africa every now and then talking about different provisions of data protection laws. Yeah, so this event is supported by Privacy Lens Africa. And then we also have Africa Privacy and Legal Practice in Nairobi. It's a consultancy firm that is based in Nairobi, providing data protection advisory services to different markets in Africa. And we have the Data Privacy and Governance Society, popularly known as Data and Governance Pros, based in Kenya. That's also a community of privacy professionals that focus on discussing data protection trends across Africa. And of course, Tech Hive Advisory, the event host, is a tech policy advisory and research organization. We advise organizations on intersection of business, technology, and law. And our core areas of expertise include data protection, cybersecurity, digital health, startup advisory, AI governance, among others. So we have a lineup of speakers, experts on the call that will be talking about the data protection landscape in Africa and what we should expect in the coming year. A lot has happened, like I mentioned. So I'm just going to hand over to Victoria to introduce our speakers, and then we get right into the conversation for today. Thank you.
Hello, everybody. Good morning. My name is Victoria. Thank you very much, Dorcas, for the introduction. So now we'll be listening to speakers introduce themselves. Trust me, when it comes to data protection and AI governance in Africa, we have the best of the best to speak to us today. And I'm very sure that you gain valuable insights from them. So we have Cherry on the call, we have Ridwan, and we have Label Gang. So I'll let them introduce themselves in the order in which they appear on my screen. So luckily, Ridwan is in the middle, so it will be the middleman today. So we'll go first, we'll start with Cherry, and then Ridwan will be the middleman, and then we'll have Label Gang. So Cherry, you have the floor.
Thank you very much, Victoria, and Tech Hive for organizing this event. My name is Sherry Oyer. I am from Kenya, and I am a lawyer and a data protection expert practicing here in Kenya. I work at the intersection of law and technology on a day-to-day basis, and I'm also a member of the Data Privacy and Governance Society of Kenya, popularly known as Data Privacy Pros or DPGSK. And I'm very happy to have this conversation today. Back to you, Victoria.
Of course, we're excited to have you too. So now we go to the middleman, the man in the middle, Ridwan.
Hi, everyone. My name is Ridwan Olede. I currently lead the AI governance and the technology policy teams at Tech Hive Advisory. But in addition to that, I also serve as the director at the Center for Law and Innovation in Kigali, Rwanda. I do quite a number of work around the space, also a researcher. I do all sorts of things really, and such a pleasure to be here, and also sharing the stage with Sherry and Label Gang, who are a good friend of mine.
Thank you very much, grade 1. So now we go to Labor Gang. Level Gang, are you with us?
Sorry, I was just having network.
Can you hear me now?
Okay, we can hear you now.
Okay, hi. I'm Lebogang George. I'm from Botswana. I'm an attorney, a corporate commercial attorney, and a data protection and data privacy expert.
So thank you very much to our speakers for joining us. Like I told you earlier, we have the best of the best in Africa here with us today. And today they will be talking about the key trends that have the key events that have happened in the data protection and AI governance space in this year. And also they would be telling us what to expect next year. So we're excited to have you. And I think now I would see the mic to Dorcas to get right into it.
All right, thank you very much, Victoria. We're happy to have all of you on the call today, and I'm very excited about this conversation, to hear from you, your own perspective about things that have happened, right? So this year we've seen a lot of developments. We've seen new laws being introduced. Some have been enacted already. We've seen enforcement actions. We've seen an increased number of data protection authorities, and also in the AI governance space, we're also seeing a lot of trends across Africa. So I would like Ridwan to walk us through the key milestones that have been achieved this year in the data protection and AI governance landscape.
I mean, getting started into it, I like to group what I would call like noted pull trends this year into there are some things that are recurring, and there are some that I would describe as relatively new, not necessarily new, but it's getting more apparent. So for me, as it relates to the recurring ones, is every year there's always like what we've seen in the last 5-6 years, for example, there's always like a new law, there's a new authority being created or designated. And then you see this year, interestingly, Togo has had his law as of 2020, finally creating its data protection authority. You have the DRC, Congo, everybody showing up on the map this year, adding up to the list of the countries with data protection laws. And we'll have a data protection law and also a data protection authority. We also have either some new laws or some sort of amendments. And interestingly, Lebogang is here, who's probably going to speak more about what's happening in Botswana with the amendment they had this year as well. But beyond that, we're also seeing proposed laws that are also making it down the pipeline. Cameroon is accelerating work to ensure it's able to get its law across the line. Maybe before this year wraps up, maybe sometimes early next year, we don't know yet. But that's something interesting that's happening. Another thing we're also seeing is like the picking up in the trend of fines and sanctions. For me, Kenya has been like the biggest name when it comes to sanctions this year. Literally almost every week there's something coming out from the ODPC. But outside of that, there were also things we see in places like Nigeria, enforcement notices from South Africa. You could also see new authorities like the one in Eswatini, for example, also doing something along that line. Another interesting thing also, which again I say they are recurring because they happen literally almost every year. If you look at what has happened in the last 5-6 years thereabouts, is also the data protection authorities either issuing some form of guidance or publishing some sort of a document. And you can see that from Kenya to South Africa with the clearer guidelines on direct marketing. Basically, these are like some of the key things you've seen. So when you shift a bit to AI governance, some of the interesting things you're also seeing is proposed laws coming up in Morocco, in Egypt, Nigeria has like 3 different views, trying to do different things or somewhat related things on AI, for example. You're also seeing things around countries either publishing or about to publish the national AI strategies. From Zambia, which is like the most recent one, early this month. You see Cote d'Ivoire also wrapping up its process. Kenya is somehow finished its consultation. Nigeria pushed out a draft that called for public input. So quite a number of things are happening. We're also seeing increasing calls for AI-specific laws in different countries, from Kenya, Uganda, Nigeria, Zimbabwe, where members of parliament have actually been very vocal about the need for AI-specific law. I'm not a big fan of, laws chasing technology specifically, but speaking about trends, these are some of the things that we've seen. And just to make sure I don't speak about everything that's happened this year, so I'm going to share right now, Lebona and Cherry coming as well.
Yes, thank you very much, Ridwan. That's a lot. A lot has actually happened, and a lot to also learn from developing new laws to proposals, and we hope to see that next year there will be more laws. Even the ones that have started, the proposed laws, we see them being completed next year. So it's actually a lot to look forward to, right? So speaking of new laws, we know that there's a new kid on the block. There is a new law in Botswana. It's not that Botswana has not had a law. They've had a law, but it took forever to come into force. Different issues with the law, and then it was finally amended, and then we now have a brand new law. So picking up from that, Gang, what do you think is the impact of regulatory development around new laws, and how it does it impact businesses in general?
I think, first of all, like you're saying, it's completely new to Botswana. It's completely new to the business landscape in Botswana. So we're still trying to navigate it, and hence why it's been taking so long, and hence why the transitional period has been extended every single year. And people are wondering, why is that? Is that because we're not taking privacy and data protection seriously? No, it's not. It's just that from both sides, the new regulatory kid and businesses and individuals and civil society, we're trying to navigate this. We're trying to learn it. And we're trying to see how best we can be compliant, both as businesses, how best we can exercise our rights as individuals, as data subjects, and also as a regulator, how best also to toe the line and balance and make sure that it's not punitive, but at the same time, people take it seriously. So as you've heard, it's been extended again until the 13th of January, 2025. And we've been informed that this is the final extension. And businesses are, on the one side, they are complying, or they're on their road to compliance. And they know that this law means that they need to be ethical in how they do business. They need to be transparent with their customers, their clients, their data subjects, in what they do with their data. And they need to be accountable in terms of what is required with the Data Protection Act. And on the one side, there is a bit of trepidation from businesses because they're not sure what compliance looks like. There are no guide notes, there's no guideline, there's no framework from the regulator to show them, okay, what does compliance look like? What do you have to have in terms of policies? What do you have to have in terms of your IT systems and your processes? So there's also a bit of trepidation because it feels like we're going to get caught because we don't know what compliance looks like. And there hasn't been a lot of capacity, unfortunately, from the regulator in public awareness and education, both on the side of data subjects and data controllers or data processors. So it's a thing of we're doing it and we're trying to be compliant, but practically, is the regulator going to say that we're compliant after the 13th of January?
Thank you very much, everyone. That's an interesting point you raised there. Providing guidance for compliance. That's a big issue for a lot of countries in Africa. While some countries like Kenya are focused on both enforcement actions and also issuing guidelines, most regulators in other countries do not do that, right? So that also takes me to my next point on enforcement actions, and I'll take that to Cherry. Jerry, you're familiar with the Kenyan data protection landscape. You've seen the regulator has been very proactive, issuing sanctions, fines, and also guidelines to guide organizations on compliance. So how do you see enforcement action shaping compliance in the data protection landscape among data controllers and processors? Do you think this is a good approach, or what other approaches would you suggest regulators should take besides enforcement actions, as other regulators are doing?
Thank you very much, Dorcas, for that question. I think just the way you're saying that we've seen a lot of enforcement action by the Kenyan ODPC, that is the Office of the Data Protection Commissioner. But also, when you look at it from a very wide spectrum or a very wide lens, it's also indicative of the fact that now we have more awareness of the data protection law and in terms of the public. So what once we had the Data Protection Act enacted in 2019, a lot of people did not really know about what it entailed or what their rights under that act meant. But we've seen that a lot has been done in terms of capacity building of the public, and that is very commendable, because again, we would not have this, we would not have as much of the enforcement notices coming out of that office without the contribution of the citizens. So that is very, it's also very indicative of how the Data Protection Act has evolved and has been operationalized in Kenya. So remember that we have just celebrated 5 years of the Data Protection Act being enacted in Kenya, and I think in 2020, that's when we had the ODPC coming into office. And what the ODPC started off as was not really into issues of enforcement, but we saw a lot of giving that grace period to different data controllers and processors, and also just building capacity. Another thing that you also seen in terms of that enforcement and that awareness levels is that the office has also decentralized, so that it is not only in Nairobi where we initially had it. And what was the conversation at that point was that most people in other parts of Kenya did not feel the need to even comply because there was no offices in those areas. But now with that decentralization and taking it to different counties within Kenya, then we see that now there is more and more people realizing what their rights are, and then there's that implementation. But just away from that, also maybe just to talk about some of the trends that I've also seen that are very interesting for me. Other than that, just having the laws being put in place. We're seeing when we started off conversations about data protection, there was that push and pull between lawyers and ICT professionals. They are the ones that are the lead in terms of doing data protection or providing data protection services. But now we're seeing more and more entrants to this field. For instance, we have compliance experts, for instance, legal compliance, for instance. We have auditors as well. You have HR also coming into this ecosystem. So we've seen a lot of new entrants into this field. I think what we had, the projections we had at the data protection, the privacy, data governance and privacy. Data Privacy and Governance Society of Kenya last year, the projections we had a lot of people from the private sector, and we had a lot from lawyers and ICT professionals, but you're seeing more people from different sectors also coming in as well. And also we've seen also in terms of sector guidelines as well, and another trend that you're also seeing, that there's guidelines that are sector specific. You've seen, for instance, in education, in finance, for instance, and this is because of the huge amounts of complaints that are coming from this area. So the Data Protection Commissioner then feels the need that there's a need and a gap there, and therefore it's filled through guidance and all that. Also, maybe to talk about the Kenyan aspect also. We saw, and just in terms of collaboration, just not in Kenya in itself, but we saw this year the Kenya also hosted the network of African data protection authorities, and that is very interesting in terms of that collaborative effort, in terms of that also the working together of the different authorities that have come into place since we started having data protection authorities being put in place. But also, I think another very interesting thing in terms of that professional aspect is that when we started off these conversations about the profession, it was always a gray area in terms of certification and all that. But you've seen, like for instance, Benin, the authority, they are coming up with regulations, or rather guidelines on how to certify professionals. And I've seen also Kenya also now has a document that is out for public participation and public comments, that is also dealing with issues of how auditors, data protection auditors, have to be certified and what qualifications they would have. So it's very interesting to see this kind of developments in terms of just in 1 year, the kind of developments that we've had from 2020 to 2023. Back to you, Dorcas.
Thank you very much, Sherry, for that very lovely contribution. So I think I should put it out there that as far as it comes to data protection in Africa, I'm a very, very huge fan of Kenya. So this is me fangirling GODPC. Yeah, so we move to the next segment of our question, and I will be directing this question to Lebogang. So the question basically deals with addressing cross-border data transfer issues within Africa. We understand that there has been this conversation around interoperability among African countries, and also having a system that allows data to flow from one country to another. But different countries seem to have different perspectives of this, especially Botswana. I know the recent Data Protection Act from Botswana has a soft data localization provision. So we just want to so the question is, with the increasing adoption of data protection laws in Africa, how are countries addressing cross-border data transfer issues within Africa? So we just want to know what you think about that.
Okay, so first of all, the old act, I'll call it the old act, the 2018 act, right? It had categorically stated that it's forbidden for personal information or personal data to be shared from Botswana to another country. Unless you can show that that country, because then there was a list of countries that were considered safe. They were considered safe because they had data protection legislation and they had adequate security. So there was a list that was passed out that these are the countries that you can share with. If they're not in this list, you're not allowed to share with it. You have to ask for permission from the Commission first. Then the amendments came because I think business was then up in arms saying, but it's not practical for us because we are doing business with these countries that are not in the list. And for the sake of our business and for business to carry on, we have to ensure that these businesses, we can still do business with them, we can still share data with them. Hence now the amendment. So now with the new amendment, the act says that Botswana can share data across countries, and that you, as a data controller, just have to do your due diligence. You have to make sure that that country that you're sharing data with, be it Kenya, be it Nigeria, be Angola, Ghana, whichever country you're sharing with, just make sure that you've done due diligence. They have adequate legislation in place. You have a binding contract with that other data controller, so that your responses are clear, so that you know who bears the liability, what happens with breach, and what the data subject, who the point is in terms of data subject request. So then there was that, because I think the new legislation or the new amendment just sees that obviously data is an economic value. We are always sharing data. There's no way that you can control or restrict businesses, especially in Botswana, because you deal with international businesses. There are very few local businesses in Botswana. It's a small country. Most of our businesses, or most of our private businesses, are made up of international businesses. So if you say we can't share data, then you're really crippling their business model or their businesses. So so now this act is allowing that, and I think it's a good idea. Yes, as much as localization, I get the argument for localization, because the argument for localization is you want to have control of your data. You want to make sure that you know where your data is sitting, how it's used, because when you share your data, as much as you have contracts in place, you're not sure whether that data will really be sitting in that country that it's supposed to be sitting in. You don't know who they're sharing it with. So as much as I get that, but I also think that we need to be realistic about, if you want to do business in Africa, if you want to do business with other countries, we also need to be amenable to allowing the transfer of data, and also just holding them account and making sure that we do our due diligence, making sure that we're doing it with countries that have the data protection legislation as well, and it's as adequate as ours, or even, if not even better than ours. So our legislation also talks about, if you're going to do this, just make sure that you have a copy of the personal data sitting in Botswana. You know, make sure that you have a contract, like I said, and make sure that you also obviously obtain consent from the data subject, so they are aware that their data is not in the country, it's exchanged or it's sitting somewhere else, and that they can also have access to their data by virtue of the copy sitting in Botswana.
Thank you very much for that lovely contribution. I think I should reiterate again that as far as data protection and AI governance in Africa is concerned, we have the best of the best in our midst. And I mean, you have just been dishing out the wisdom, and yes, that's much appreciated. So let's go to the next question. And my next question, I'd be directing it to both Lebogang and the man in the middle, Ridwan. So I think Ridwan's nickname for today is man in the middle. So I'll be directing my question to both of them. So yeah, when we talk about data protection in Africa and emerging technologies, we are beginning to extend the conversation basically to children, because now we are not so shielding children from the use of technology. Technology is now being used in every aspect, and that includes the educational sector that directly impacts children. So, so my question is, what are the most important trends in child online protection across Africa, and what are your thoughts on the current approaches? Because again, I know that some countries are beginning to make efforts to ensure that as much as children have access to technologies, emerging technologies particularly, that there is a level of protection that we can afford children, right? So what are your thoughts on the current landscape and the current approaches that we have towards that? And what do you think is the impact of emerging technologies on this development? So I think I would like to start with Ridwan on this.
Yeah, I mean, I'm just going to chime in real quick on, the last question you asked, about cross-border data transfer. And I mean, I find Botswana's model really interesting because before the new act, under the old act, there was a list of adequate countries that was published, and it included, I think, South Africa and Kenya as African countries. So I don't know what the status of that particular regulations will be, since it's not clear, like it's been thrown away. But I think another interesting thing that is emerging on the continent, in Kenya this year, I remember during that PA event, there was an announcement that Kenya is seeking adequacy decision with the European Commission, which is quite interesting anyway. If it gets it, it's going to be the first African country to do that. But before Kenya, there are other African countries who have tried, Mauritius, Morocco, at different times. They all tried to apply for the adequacy decision and they didn't get it. And I think another interesting thing we're seeing is also, if you look at Rwanda, Rwanda is the first African country who has the provision for standard contractual clauses that has actually published one coming from a regulator. And it's really quite an interesting document. It's just about 12 pages, really short, concise. It's just one module for now, which is really an interesting one. Another thing we're also seeing is also the gradual popularity of cross-border privacy rules, CBPR, global cross-border privacy rules. So first, last year, towards the end of last year, Seychelles passed an amendment to its 2003 law, and it's the first country that included, global cross-border privacy rules in its law specifically as a mechanism to facilitate cross-border data transfer, which opens up a new opportunity. But before then, there have been different African countries who have been having conversations with the US Department of Commerce, who has been one of the biggest advocates for CBPR as a transfer mechanism. So you've seen Kenya on one side, you've seen Nigeria on one side, who have been having this conversation. And recently, Nigeria was attending an event in Taiwan, which was also about the CBPR countries and, whether we're going to see African countries embracing the CBPR, it's going to be an interesting conversation. And another thing to add to that is, at different times this year, there was some sort of an agreement between the US and Nigeria and Kenya at different points. And aside talking about AI governance as one of the key things they are trying to achieve, one of the things that was also mentioned was also CBPR. So it's going to be interesting to see what the next year brings in terms of whether CBPR will be some sort of alternative mechanism to facilitate cross-border data transfer in Africa. But beyond that, different countries are taking a different approach. Uganda is trying to amend its law as well. There's a whole conversation about amending its law because the current mechanisms for data transfer are not so business friendly. So there's a whole conversation around amending that. We're seeing different conversations across different parts of the continent. So now back to the conversation about child online safety. We've seen interesting trends. Different countries are taking different models, but it's not just the data protection authorities now playing a role. It's taking a multi-sector dimension. It's taking a multi-regulatory dimension. In Rwanda, for example, There was a ministerial order specifically on online child safety. There was, bunch of obligations from age gating to making sure platform ensure the best interest of the child is preserved. And a bunch of really obligations on service providers to ensure that children's interaction is kind of safe. But beyond that, we're also seeing countries like Nigeria who are opening up the conversation through the Nigerian Communication Commission, something around online safety as well. There's a draft document currently guiding the whole policy, national policy, online engagement as well. At the continental level, we're also seeing a few things happening. And I think, even though we've not gotten to the part to start talking about predictions, but I think child online safety will be part of the biggest conversation next year. And that's becoming more important because of what is also happening in different parts of the world. In the US, there's a whole policy, there's a whole legislative around more specific child online safety regulation. Australia has seen the introduction of the law that now prohibits people that are below certain age from actually having social media accounts. And where you see the trend is going is we've seen different countries like Mali, Senegal speak specifically about different platforms, issuing out warnings about how children are engaging on these platforms and how platforms are being problematic for kids. So if you look at the line of the conversation, you begin to see a trend emerge, which is why I feel strongly conversation about child online safety will be very big next year, whether it's going to be whether it's going to be the Data Protection Authority, whether it's going to be a Competition Authority, whether it's going to be a Consumer Protection Body or the Communications Regulator or the Cybersecurity or cybercrime units in a particular country doing this or taking the initiative, or maybe even as a matter of national policy. I think it's going to be one of the biggest things we're going to see in the coming year.
Okay. I think from our side, as much as our law is new, with the amendment, the good thing is they actually did make reference to children's rights and children's privacy, which they previously hadn't in the previous act. So you're seeing that now they're taking that seriously, and that there has been talks about probably also having another regulation speaking specifically to children's rights and children's privacy. As much as we have an overarching Children's Rights Act and we have the Constitution that also protects children, the regulator saw it fit to have a section talking about children's rights and direct marketing and their right to privacy and online marketing as well as online purchasing, because we do know that the reality is kids will have their parents' phone and they'll be purchasing things on their parents' phone, and their information is also taken. So our law actually makes provision for that. And there is talk about maybe we should have a separate regulation as well, specifically speaking to the right to privacy to children, so that we can address that broader. And it's not something that can just be interpreted in a one line or in a section in the current act, but it can be a comprehensive act talking to children's rights and their right to privacy. And I do think that we have seen with technology, I've seen that Apple has also done the whole privacy by design, and it actually has done it in a good way where their technology, when you're using their software, when you're using, whether you're using their phone, whether you're using their devices, it actually has a tool that can detect and see whether this belongs to somebody that is much older or if this is a minor, and how to deal with that sensitive information. If it is a minor, how they're dealing with that sensitive information as well. And also the communication between the guardian or the parent to inform them that the child has checked into a certain website and do they have their consent. So I think that technology companies are also slowly trying to really take into consideration this whole thing of privacy by design and making sure that everything that they do in the back of their mind, whatever they're designing, whatever new technology they're designing, whatever tools they're designing, whatever AI machine or tool they're designing, at the back of their mind, it's all about data protection, and it's all about the protection, whether it's a minor, whether it's just the data subject who's over the age of 16 or 18 or 21, then at least their rights are protected as well. So I think we're seeing that slowly companies, entities, businesses, data controllers are also really embracing this whole privacy by design, because it forms a huge part of making sure that you're protecting people's rights, and especially minors.
Thank you very much for that lovely contribution. It feels good to know that children are becoming a very huge part of the conversation, and more consideration will be made to protect them when it comes to the use of technologies and emerging technologies generally. So my next question is directed at Cherry. And yeah, I particularly like that you will be speaking to this, because when it comes to enforcing data subject rights, the ODPC has been very radical with ensuring that organizations respect data subject rights, respond to data subject rights requests within stipulated time, and also ensure that issues like consent and the exercise of any data subject right at all gets sufficient attention from data controllers and data processors generally. So our next question is basically addressing the issue on data subject right enforcement. So I know that with regards to enforcement, we have seen that some of the enforcement notices and even fines that have been issued across Africa generally this year, they have really had something to do with enforcing data subject rights and having that as a focal point. So the question basically is, have we seen any unique approaches to data subject right enforcement in Africa compared to what we have in other regions?
Thank you, thank you for that. Yeah, definitely we've seen some changes. Victoria, I mean, in terms of even the amounts that are being the fines that are being the amounts that are being fined, we've seen that they have gone a bit higher. Like before, we saw the very I think the ODPC was a bit lenient when it started off doing the enforcement notices, and they're a bit more lenient. But interestingly now, when the Data Protection Act provides that other than just the fines, also there's also that possibility of holding accountable, personally accountable directors, for instance, where there's breach and where there's non-compliance. And I think I just might forget the exact citation, but there's a case that the Data Protection Commissioner handled, where there was an enforcement notice that was issued against this organization for breach of the Data Protection Act, in terms of it's of course unfortunately they are this sector is very usually very they're notorious for the breaches. So this is in the lending sector, a digital lender. So what had happened is that they had shared personal data, of course, and breached data, the Data Protection Act, and it was not the first time. And the Data Protection Commissioner had issued an enforcement notice, but on the day of so once that had been done, they, of course, the procedure is they get to defend themselves. The Data Protection Commissioner wanted to go ahead and to inspect whether what was on paper with what exactly was on the ground. And we also know that most of the times, unfortunately, what you see even from practice is that usually the people actually are compliant on paper, but not really in terms of operationalizing those policies that they have put in place. So what happened is that on the date of inspection, the organization hurriedly closed down. And because this was the second time this was happening, then we saw that now the Data Protection Commissioner actually went ahead and now has issued penalties against personally against the directors personally. So we're seeing that evolution of I mean, when the Data Protection Act was enacted, and even as we progressed from 2019, there was always that thought that this the Data Protection Commissioner would not really be evoking these provisions this soon. But we've seen that this is happening now. So in terms of enforcement, I think also that is it's just the way that we're seeing that there's that progression, but also I think also with the enforcement, and I think most of the people who practice in terms of compliance issues as external or internal data protection officers, they will attest to it, that every time there's an enforcement notice that is affecting a particular a particular sector, then you're seeing that sector usually now starts really looking into compliance, because we've seen also that some of the challenges that we've seen in terms of taking up data protection seriously was that a lot of organizations really did not ingrain this in their cultures. They really did not put this as they don't really prioritize it. But immediately you see the enforcement notice that is affecting one particular sector, you see most players in that particular sector really trying to ensure that they are complying. But also, again, in terms of the data subject rights as well, it's also testament to the fact that the operationalization of that Data Protection Act and the fact that now the data protection, the data subjects rights are really prioritized now, not just by the data subjects themselves, but also with the Data Protection Commission, that and this is across most of the authorities that are issuing enforcement notices, that it is no longer just business as usual, that you can use personal data the way you want and there's no repercussion or consequences. We're seeing more consequences coming in, and just very refreshing to see that it is now being taken seriously, rights of data subjects.
Thank you very much, Jerry. So I totally agree with you, and I think that the enforcement actions that we have seen recently is not just impacting the businesses; it's also giving data subjects that level of consciousness that there is an authority that can hear them when it comes to enforcing their data subjects' rights. And I mean, it's lovely to see everywhere, really. For Kenya, I noticed that this year it has not just been the ODPC enforcing the decisions, but we're also seeing that the court system, that's the judicial system, they're also upholding some of these decisions in line with the Data Protection Act, and just it's very reassuring that data subjects' rights do not just exist in the act, but we see it play out, and it's a lot of confidence that we have in the system. So yeah, big ups, and we see this, it's growing across. I think this year we've had some enforcement notices from Eswatini, we've had from South Africa, we've had some from Nigeria as well. So it's spreading across them, and we hope that in the coming year we'll see more action in that regard. So yeah, that brings me to my next question, and I'll be directing my next question to Ridwan. So the question is about artificial intelligence, and I know that you are very big on AI governance, so you're the best one for this question. So with the buzz about AI, how are African data protection authorities addressing the intersection of AI and data protection, especially when it comes to automated decision making? What are the current perspectives that we have? What efforts are data protection authorities across Africa making to ensure that, well, in the aspect of automated decision making, there is a level of compliance on that front? So, Ridwan, you have the floor.
All right. I mean, if I can maybe brag a bit, interestingly, just a couple of weeks ago, I published an article. We co-authored an article with Dorcas on the IPP's website, basically talking about what the data protection authorities in Africa are doing as it relates to AI regulation.
Ridwan, feel free to brag. We appreciate it.
Yeah, not bragging. I'm going to share links as well. And I think I recently also did another article on automated decision making. Now, African data protection laws have sort of addressed them. So I'm just going to speak to those two things real quick. So this year, what we've seen with AI regulation, especially from data protection authorities, is there have been a lot of expression of intentions. You know, if you look at very early in the year when we did like some sort of analysis on what data protection authorities heads have said, one of the countries that like showed up on our map was South Africa, Kenya, for example, who were very vocal about what they want to do about AI governance. So what you see, especially this year, is, for example, Nigeria published a draft implementation directive. One of the things they tried to do with that document was specifically speak to the governance of emerging technologies, making sure you operationalize data protection principles, and also develop and deploy responsibly. But beyond that, if you go a little bit historical, the last 5 years, for example, we've seen even some sort of form of enforcement as it relates to AI governance. And I'm going to give a few examples. In Morocco, as far back as 2018, the Data Protection Authority, the CNPD, did place moratorium on the use of facial recognition technology for about a year. So it was 7 months initially, then they extended it. Then right after doing that, he published 2 guidelines on the use of facial recognition technology. Then in Senegal published a document, a guidance on deployment of workplace surveillance tools. And he also specifically addressed the use of facial recognition technology in workplace. Then he also issued some sort of against the company that was also trying to use facial recognition, and then say, you know what, you can do this. So we're seeing that level of enforcement. And if I stretch what the ODPC did last year by also, suspending WorldCoin, because WorldCoin also had like AI, even though the reason for the suspension wasn't so much about AI violation itself, it's more about some things they didn't do right, but then it was a company that was leveraging AI. So if, by stretch, you can also maybe think about that. But beyond that, you're seeing Mauritius, for example, that has also published specific guidelines on AI deployment, on AI. You're seeing more data protection authorities being more vocal about it and their intentions on what they want to do. Cote d'Ivoire, for example, opened a public call and said, you know what, we're trying to understand this technology. So just come tell us about what it is like. So they did like an open consultation, and you see that in Senegal as well. So different data protection authorities are taking different model. So what we're saying is first trying to understand through the public consultation that some of them are doing, and then develop a regulatory response based on the feedback they get from the public. But we're also seeing those who are like, you know what, this is a big problem, we need to address them on time, which is what we saw with Morocco. And we're talking about 2018, that was way before even you have many big countries doing anything around the risk that comes with AI, for example. So, and if you look around there are also research that quite a number of authorities are also thinking around research. So move away from that. Now come to automated decision making. So the different laws in Africa, and I think roughly about 35 out of the 39 laws sort of address automated decision making, whether expressly or you could imply you are trying to speak about it. But what you see, what is a common thread is the language is somewhat similar. Even the laws that predate AI like POPIA. I'm sorry, I said AI that predates the GDPR like POPIA. They all have similar language, automated decision making, easy impacting people in terms of the decision itself or having real life impact on people. So what you see across these laws is then beyond making it a right, then they also make it, you must also disclose that the technology is being used, for example. So the interesting thing you now see is now the different level of safeguards that you find across different laws. And I think one of the interesting models that we have is what you see under the Kenyan general regulation, data protection regulation. It has arguably one of the most comprehensive safeguards when it comes to deployment of automated decision making. So what I did with the recent thing and the recent work I published on ADM was to bring all of these safeguards across the different laws together, and then say this is how the different African countries have been addressing this. So what you have is the different level of safeguards across different countries, from disclosure to making sure you're deploying measures to ensure there's some sort of like a human intervention in between it. People can actually appeal decision. You're also making meaningful process to address the risk in itself. So one thing you can say about Africa when you take it as a whole is we're not short on some sort of safeguards when it comes to automated decision making, whether it's AI or any other form of technology that is capable of doing it. So those are like some of the things that we've seen across the continent, and more specifically this year. Not a lot of it, but I'm taking the trend as an accumulated one. So we've seen different countries doing different things, and more needs to be done, of course. But yeah, that's the response to that.
Okay, thank you very much, Redwan, for that insight. And if we give you like 1 more hour to discuss that, you probably have sufficient insight to still spread across 1 hour. But thank you for keeping it short and simple. So we'll be going to the next phase of the question, where we'll be discussing the challenges African countries are faced in enforcing data protection laws. And so I think I should start with Lebogang. I'm back to you. So the first question basically is what are the biggest obstacles African countries face in implementing and enforcing data protection laws, and how can they be addressed? See, we understand that in some African countries, and I think maybe Africa generally, we cannot generally say that data protection is a new concept. It's not very new. Maybe we have some countries that are just enacting their laws, right? And then there is a big implementation. I know for Nigeria, the focus has been, let's create awareness first. Let everybody be aware that these laws exist before we go hard when it comes to implementation. Sometimes it is the participation of the citizens in enforcing things like data subject rights that is needed. And sometimes you see authorities maybe not having sufficient resources to even effectively enforce these laws. And sometimes it's because some of the big data companies are maybe not so domiciled in these countries, even though they operate across. So again, there are different layers of these challenges. So again, we want to hear from you. What are the challenges that you think that data protection authorities are facing, and how are they addressing these challenges?
Absolutely. I think there's a litany of challenges. And at the top of the challenges, I think it's also the way we have really adopted and copied and pasted, for the most part, the GDPR or European laws into our local context. And for that, it's a challenge because you're getting a lot of pushback from people because they don't understand why we have not localized data protection and data privacy, and why we have adopted or decided to adopt the EU GDPR, especially from Botswana, So I think that is also one of the challenges, because then there's a miscommunication or a misunderstanding where data controllers and data processors don't understand the law, and they don't understand why it has not been localized to the context of Botswana and how we do businesses in Botswana. And also data subjects not understanding what their rights really are in terms of the Data Protection Act, and not in a European way, but in a more local way, And I think that's where also public awareness also comes in, and education, because then unfortunately, because of lack of resources, like you mentioned, there's no one to go out there to educate them and say, these are the reasons why we decided to copy and paste or benchmark off the EU GDPR. They don't know that there's no capacity for that. So there's lack of public awareness and education. Data subjects don't know that this law, some of them don't know that this law exists. There's no road shows that are being conducted in rural areas where a lot of sensitive data in those clinics are being collected. So they don't know what their rights are. They don't know what is happening in those clinics when people are collecting their sensitive information. They don't know where that information lands, because those clinics aren't even technology or digital. They don't use technology or digital systems. They use like your old school files. So we don't know how they keep their data, where they keep their data. So those are the challenges. And I think also lack of readiness. Besides readiness from data controllers, lack of readiness from also our own regulators, because this is also new. This is new to us. Yes, privacy has always been in our constitution. We've always known that we have the right to privacy, but in terms of a legislation and following processes and policies and looking at positions and what is expected from everyone, even regulators are not sure about how do we put out guidelines and which guidelines do we put out first? How are we going to start implementing this? And they're also looking at, should we have done what South Africa did with Popia? Because South Africa did it incrementally. It didn't start implementing right away. It started piece by piece so that they can start building capacity and start capacitating themselves and teaching themselves as regulators first, so that come the time that the whole legislation is enacted and is enforced, they are capacitated. They have the resources. They also they are aware of what is expected of them as well as people, as experts. So I think it's also that it's maybe we jump into things first, and we could have slowly, incrementally started applying this or enforcing it to sensitize ourselves, sensitize regulators themselves as well, give them enough time to capacitate themselves. And also, I think the other challenge is also lack of collaboration. Lack of collaboration, I mean, we've got regulators, they're not on their own. They could collaborate with researchers. They could collaborate with academia to find out best practices, what's been done, what does enforcement look like. And that's how they can start capacitating their office, because academia, most of the time, they don't need that much money or that much incentive to assist. They're researchers by profession. It's a passion. You could start by capacitating your office with academia people to help you and assist you on best practices and how data protection looks like when it's enforced, what happens after the deadline for transition period, so forth and so on. And then another challenge, I think, this is the huge challenge, the biggest challenge actually, is budget. Lack of money, lack of budget. Because if you're going to be a regulator, you need the finances. You can't enforce and you can't overlook and be a custodian of a data protection act when you don't have the finances and the resources to carry out your duty and your job. So that's also a thing that, European regulators have budgets as far as they go, as long as 300 million euros for them to capacitate their office. And then when you're looking at African countries, we can't think of budgets that are over 300 million euros. So it's we think small and we're thinking maybe like 5 million. But what are you going to do with 5 million? And I think, and then I think lastly also it's, I think, like I said, it's maybe sometimes it's not in every African country, but also the lack of expertise, I think. Lack of expertise could also be a challenge. We have very few experts in the field of data protection, data privacy, AI. So that's also a capacity issue. I think it also speaks to a whole capacity issue.
Thank you very much for that contribution. So from what you said now, I understand that data protection authorities need everybody on board, especially the executive, the office that will approve enough budget for them to function. And then there is also a need for them to train themselves so that they know what they are supposed to do and they have the capacity to do it, and then also collaborate with other people to address these issues. Because interestingly, we had there was a report earlier in the year, a court action actually, where a data protection lawyer in Nigeria is suing some authorities in Nigeria because, according to the lawyer, the NDPC does not have sufficient funding to enforce the Data Protection Act. So again, it looks like addressing these challenges does not just lie within the data protection authorities themselves. There's a need to look outwards to the executive arm of government so that they have sufficient budget to carry out their roles and responsibilities, and also collaborate with private organizations so that they are able to understand the landscape effectively and they know how best to go about it. Thank you very much for your contribution. So my next question goes to Cherry. And so the question is, what strategies are being employed to ensure that smaller businesses and startups can comply with the increasingly complex data protection requirements under data protection laws? So when it comes to compliance, generally, data protection compliance, because of the compliance requirements, the policies, the measures that need to be put in place to protect the data that organization processes, sometimes small businesses and startups could find it very difficult because, again, what qualifies them as small businesses and startups is that they are still at the very foundational phase, and maybe sometimes they could have a bit of financial constraints, and data protection could take the back burner when it comes to this. But again, we have seen articles, we have seen thought leaders come out to say that if you really want to start at all, you probably should start right. But then there is also that consideration where they need to balance those things. So we just need to know what are the strategies that are being employed to ensure that smaller businesses and startups can comply with these data protection requirements. So Cherry, you have the floor.
Thank you for that question, Victoria. And I think as you have rightfully mentioned that a lot of the times smaller businesses really struggle in terms of compliance with the data protection laws and regulations across. I think this is across Africa, and this is usually a fund issue. So most of the times you speak to small businesses and they tell you like all the money that we have, we are directing. So this is data protection is really not a priority at this point for us. And if that is the case, but then again also the law really does not care about the size of the business, for instance, in terms of whether if they're going to be in breach of the data protection laws, then they'll still be, it applies across regardless of the sizes of these businesses. So I think some of the strategies that could work and can be taken into consideration by small businesses because of that lack of prioritization. I think the first thing is to, even for data protection experts, for instance, the first strategy is to go to take a top-bottom approach in terms of when you are speaking to business owners, small business owners, it is or people in that space. It is very important that you get the buy-in of the very top, so that once they see the importance of compliance, then they can also now have it trickle down within the organization or business. So this is one of the ways, but also very important. I think one of the very important things is also in terms of training. It's very important that as even regardless of how small it is, especially if you're taking that top bottom approach, then you teach, then there's need for training of not just the top, but also everyone throughout the chain to the bottom level. So it's very important that all members of staff are also given the training on issues of data protection and how to comply. Another thing also in terms of that top bottom approach is once you have the tops buy-in, then they can also be able to now really prioritize in terms of when they're coming up with the budgets for the organization or the institution, for instance, or the business, then they're able to set aside some money for purposes of just in terms of ensuring that they're compliant, in terms of even who they're going to hire, for instance, or even what kind of organizational and technical procedures they're going to put in place for purposes of compliance. So it's very important that other than just having the documentation, also that there's also that element of putting in the money aside for purposes of operationalizing those policies and all everything that you say in those documents. Another thing also in terms of how can small businesses, organizations, institutions also comply or be in compliance of data protection laws, is that I think for most of data protection laws across Africa are almost the same. Thanks to the GDPR, the borrowing from the GDPR. So most of them would provide for either having internal DPOs or external DPOs. I think for very small organizations or businesses, it would be very, and sometimes they really do not, the core business is not data, but at the end of the day, they're dealing with data, personal data in one way or the other. So my advice would be that having external DPOs that would come in and for instance, provide those services when and whenever necessary, and also perhaps also having audits, regular audits that they could also be able to assess how they are doing in terms of compliance, whether there are any risks, for instance. So I think having that external DPO and having or external auditor coming in and auditing their processes and documentation and just giving that advice on where they are would be more, would put less pressure on their finances in terms of they don't have someone who they have to pay on a monthly basis, for instance. So maybe it's gonna on assignment basis, so that puts a little less pressure on the financial aspect. So I think in terms of small businesses, these are some of the strategies. Of course, this is not exhaustive, but these are some of the strategies that they could put in place in terms of compliance.
Hey, Cherry, thank you so much for that contribution. We cannot overemphasize the importance of budgeting. Businesses must prioritize budgeting for data protection because the cost of non-compliance is always more than the cost of trying to comply. So it's better you just comply before you get fined or you suffer something else and lose your business, trust in your customers trust in your business and all of that. So thank you very much for that contribution. And I hope that we are having a nice time so far, and business owners in the house are also taking note of this very important point. So I would we're gradually coming to a close because we'll be looking at projections very in a few minutes. Although we've already even spoken about a lot of things that we'll see happening in the coming year already. But just to sum it up, so before I get to that, quickly get Read One on board to share insights on some of the challenges that African regulators are facing in enforcing AI-driven data processing. I know that you've written a lot on this. You've already highlighted some of these issues. So just to bring you on board to talk about it. And also, we have some documents in the chat. You can look at them. Those are things that everyone has written about already. And see after this. So over to you, Read One, please.
I mean, quite a number of interesting things are happening across the continent, especially when you take it as a whole and not just singling out, countries. As a continent, another interesting thing that happened this year was, for example, the digital trade protocol that eventually, got into full effect. One of the key provisions under the protocol is also the need for countries to make specific regulatory interventions or policy interventions around emerging technologies without singling out AI, of course. Another interesting thing was the African Union continental strategy, for example. I know a bunch of recommendations are now moving into the implementation phase. One of the things you also found there is also like the need for national response to whether it's a strategy or whether it's a policy. Different countries are responding differently to AI governance. So we're also seeing some sort of economic bodies, regional bodies doing a few things around ECOWAS, for example, trying to amend its EAC having different level of conversation around cross-border data transfer, around data governance. We're seeing countries also introduce things like national data policy. And so when you bring all of these things together, you're seeing different approach to how different countries are thinking about how they want to go about it. Rwanda has established its responsibility. So many countries already have some form of task force or whatever task force or council or whatever name they choose to use. So when you bring all of these things together, you're seeing a picture where and when you look at also the countries who have introduced some form of AI-specific legislative proposal at the national level, you're also seeing the trend where people want to respond. I mean, on a personal level, as also like someone who works in regulation and policy, I'm not a big fan of making technology a focus or a target of regulation, because what we have is always going to be like sometimes the pacing problem. And it's easy to point to different parts of the world where there are AI-specific laws, but you realize AI-specific laws alone don't anchor by themselves. You also have to define your liability regime, your IP regime, and so many other frameworks that you also have to give life. So maybe in our own reality, because of paucity of resources, the challenges that we already have, the fact that capacity could also be an issue across different countries. So why are we not thinking about, okay, I mean, I have a big proposal I always talk about, which is always the clearinghouse model. Why can we not work? If we want to actually focus on is the risk of this technology or specific technology, okay, should we then address the risk? So how do we address the risk? Can we look at what the current laws are saying? Or first, can we even define what the risks are according to our reality? Because the way a risk will affect an African woman who's probably in a certain context, who's probably trying to get credit, will probably be different from the way it's probably going to, affect a woman in a developed country. So it's contextual. First, being able to contextualize their reality, and then making a decision about how we want to choose to respond. So if the risk is what we want to do with, okay, we already have competition law framework that can deal with anti-competitive behaviors, abuse of dominant position, which will become an issue. You have competition law, consumer protection framework, from things like deceptive. I've done a lot of work on deceptive design as well, but from things like deception, misrepresentation. If you're promising more than what your product can actually, it's a purely consumer protection issue. There's a data protection law that is mostly principle based across different countries. They are technology neutral. So can we expand on these principles? Can we expand on these provisions and maybe apply them? Countries have cyber crimes laws, countries have cyber security laws, there are product safety laws in different African countries. So can we, especially if they are like principle written, not so rule-based, which confines them to a minimal flexibility. So if the risk is what you want to address, can we start thinking about maybe amending the existing laws rather than crafting a new set of law where we now have to design a new regulatory body? We've seen some AI strategies say you need to create a specific body to regulate AI. So if tomorrow now, I mean, one of the big tech companies talk about quantum computing, for example, profession is probably moving towards quantum computing, then we have to create a new body for quantum computing, and we move from quantum computing, we move to another emerging tech, and we keep creating new laws for every technology. So again, the pacing problem. So I think the summary is the challenges are there, but we can also find a local way to deal with some of these problems. If it means amending laws, if it means using secondary regulations to address, to create guidelines for compliance, data protection authorities have a lot of powers. They can create regulations, they can create secondary, many of them have power to create secondary regulations. And you can basically use part of the law that gives you the power to do something, expand on it, create more specific rules around what you want. We're seeing sector-specific approach as well. Nigeria, Egypt, Mauritius, they've all introduced sector-specific AI regulations regulating things like both the financial sector. So, I mean, there's so much that can be done without necessarily, falling under the peer pressure to have AI-specific regulation, which can, of course, again, you need to figure out, do you want to regulate foundational model? Do you want to regulate the risk of the hand? So whatever it is, look inward and then you find the solution. But for me, a clearinghouse model works because we have an opportunity to bring the resources of all these existing bodies together, all these authorities, and then they can jointly investigate, they can split resources, they can split knowledge. But that also has its own problem because they also have to, that's also working under the presumption that they also have capacity. So that's also something that needs to be fixed.
I completely agree with you on the point of crafting new laws. We're always quick to jump to the next best solution, which is to develop entirely new laws to address every issue, even before understanding the issue. So it's always good to leverage what we have. So picking up from that, what are the trends that you see happening in the AI governance space? I don't want to take your breath, so just keep going. So tell us the trends that you foresee in the coming year in the AI governance landscape.
I mean, as far as AI governance is concerned, we're going to see, I mean, like I said, this year already, quite a number of countries have already introduced draft laws. We're going to see some progress with that. We're going to see more sector-specific interventions. We've seen in the financial sector where robo-advisory, for example, there's specific regulations to address them in some market, like, Mauritius, Nigeria. We're going to see a lot of amendments to traditional laws because maybe now countries are also there thinking about how the existing laws sort of go. Tunisia, for example, is trying to amend its IP law to start factoring things like how them into part of the creative process. So we're going to see a lot of push for amendment of traditional laws. I mean, laws designed for traditional domains to now address some of these new phenomena or some of these new manifestations. We're going to see I also expect to see one or two data protection authorities put out some sort of guidance specifically on AI. A lot of them have been very vocal about it, but I think it's a race to who's going to act first. We're going to see the trend around more consultation like we've seen in Senegal and Ivory Coast. I expect some other data protection authority to also open that pool to actually work with stakeholders and say, you know what, let's learn together, let's learn the risk, let's understand the risk before we design a regulatory response. I think another interesting thing we're going to see is maybe the coming year we're probably going to have that first country and we're probably raised to having its first law. What the quality of the law will look like, I can't say for sure, but that's something that we're going to see, especially with, like I said, in Nigeria, for example, like 3 legislative proposals, all speaking to trying to regulate AI. How fast this will move through the legislative crunch cycle, I think it depends on the political way to also get it past it. But we may see something. Another thing we're going to see that I see is we're going to see a bit of more collaboration between the different regulators across different domains. So playback. Last year and the last 2 years, we've seen the competition authorities in Africa publish a statement and say part of what they want to do is also to collaborate with other authorities, which includes the data protection authorities. In Nigeria, we've seen a model where the data protection authority and the competition authority have come to say, you know what, we want to address a problem like digital lending. So I also expect some sort of coordination as far as it relates to AI governance in the coming year or in 2 years' time, as you may see. But by and large, I think it's going to be a big conversation. It's not going to slow down. That's not going to be the case. We're also going to see more legislatures across different countries also being vocal, like you've seen from Zimbabwe to Uganda to Kenya to Ghana to Nigeria this year, for example, where speakers or some of the heads of these legislative bodies have been very vocal about the need to hire a specific law. So I guess those are like some of the things we're going to see. They're going to continue to happen. But for me, I'm not putting my bet now, but I'm very big on, seeing some of these things happening slowly. And I think we would eventually get to that point where we'll probably see a country eventually so close to having a law, eventually having one.
Mm.
Thank you so much, Ridwan, for that insight. I completely agree with you. We're going to 2025 is actually going to be a big year for both data protection and AI governance. With the momentum that we have seen from different regulators and governments, it's definitely going to be a big year for us. So moving over to data protection, I will let Lebogang come in now. What are the trends that we see coming in 2025 in the area of enforcement, new laws, and then even the proposed laws? Do you see these laws coming into force? Do you see them dying a natural death like we've seen with so many other laws? And there's some laws that have taken so much time to be completed. What do you think? Laws like in countries like Namibia, for example, what are the trends that you foresee in that area in 2025?
I think we're probably going to see more industry-specific regulations, especially when it comes to your sectors that deal with copious amount of data, even sensitive data, like probably your education sector, your health sector, because already in South Africa, we're seeing, and there's talks as well in Namibia about a health and data legislation. So we're seeing that. We're seeing trends regarding banking and also your financial institutions. We're seeing legislations and regulations that are going to be more specific to them because they are highly regulated anyway. And also they collect a lot of data as well. And I think we're also going to see a lot of, there was talks in SA as well, and not so much in Botswana, but I think when your neighboring countries having those talks, we are probably going to follow. So there's trends about also certifying your IT vendors and your IT vendors as well, making sure they have certifications, making sure that whoever you are outsourcing your IT to, they have the certifications, they can show that it's up to a certain standard. So we're going to probably be seeing that third parties and vendors in your IT and your IT processes are going to have certifications as well. And I think also we're probably going to be seeing voluntary audits. Just your regulators, because of enforcement and lack of public awareness and education, we're probably going to see them coming in and saying to your data controllers or data processors, let us audit and see where you are and how far you are. That's been happening in other African countries where regulators are doing that, especially where maybe there's lack of public awareness that's been happening in education on the ground. Then they will do your voluntary audits just to assist so that your data controllers and your data processors are not caught unawares, and they know what's expected of them from the regulator. And I think also what was mentioned was also MOUs. Probably also a collaboration or MOUs with other regulators. Specifically, I think in Botswana, you might see maybe a collaboration with the competition authority who's also the consumer protection authority. They sit in the same building, so they are one and the same regulator. Because we do know that a lot of data protection breaches are done, against your consumers. So we're probably going to be seeing an MOU and collaboration with that as well. So I think those will probably be the trends, and maybe, like I said, also a regulation or maybe a guide note on how to deal with privacy insofar as it concerns minors. And hopefully in our country, which I would love to see, is more guidelines and guide notes coming out as well to guide data processors and data controllers on how to process and deal with data lawfully and legally. So I think that's what we will see. And yeah, and we're looking forward to that. We're looking forward to that. it's scary times, it's interesting times, but I think we'll be able to go through it because we've got a lot of framework and a lot of countries to benchmark from.
Thank you very much, Debogang. I completely agree with you. And if you see all of this in 2025, I think the world will be a better place, right? So we're really looking forward to having more guidelines and more guidance basically from the regulators. So everyone knows what they are doing. It is a lot clearer, and then compliance is much easier for everyone. Yeah. So picking up from that, I would love for Cherry to just give us a little bit of insight on enforcement actions. Picking up from what the Kenyan Data Protection Authority is currently doing, what do you foresee 2025? Will this serve as an example to other regulators? Are we going to be seeing more fines and more sanctions from other regulators? Are they also going to pick up from the example of issuing guidelines and regulations to guide compliance with data protection rules?
Right. I think I think we can only go higher as the years go by. I think again, just maybe referring to what I had said before earlier on, is that with more members of the public or citizens knowing about their rights under the Data Protection Act, then we're having more complaints, and I think that is only going to get better in terms of that public awareness. So I'm foreseeing, if I was to put up a crystal ball, I'm foreseeing more complaints to the Data Protection Commissioner, and I'm seeing more enforcement notices coming in as well. And I think also I was in a forum with the Data Protection Commissioner recently, and there was they were saying that also, other than just doing the enforcement notices, also what is going to be happening is that because during registration of data controllers and processors, what usually happens is you have to submit documentation in terms of what technical and measures you've put in place for purposes of compliance. And now what is going to be happening is that the data commissioner is also going to flex its investigative or inspection arm, and will be going to different organizations or companies and all that to inspect whether what is on paper is actually what is actually being implemented. So that therefore means that unfortunately, I'm foreseeing that there's going to be more and more enforcement notices and more of that. Just I mean more compliance or requirement for compliance. So I think this is when once that is happening, also in terms of how other regulators across the continent perceive this, I think then that is just going to be a precedent that is being set, and I think most of regulators will also fall into this, because again, because we are all in the same age bracket, or in terms of these regulations and laws, different countries, we tend to really borrow and look at what each and every one of us is doing. So I think what Kenya is doing, maybe setting that trend in terms of enforcement, then I think that will then just cascade into different countries doing the same, or different regulators doing the same. So I'm looking forward to seeing how this plays out, and how again that influence to other countries as well, and also borrowing also from other countries as well. I'm really looking forward to that as well.
Thank you very much, Jerry, for the insights that you have shared. So we have come to the end of the questions, and now we'll just take one question from the chat that we already have. So I think this question is directed at Labour Gang, and it says that, hi Labour Gang, when do you expect the promulgation of the 2024 Data Protection Act in Botswana? I think this person is talking about when you expect the Data Protection Act to actually come into full force in Botswana.
This is going to be after the 13th of January 2025. So that's when the transition period lapses. So by the 14th, from the 14th, every data controller, every data processor should be compliant with the Data Protection Act. So then now the grace period, the honeymoon period has ended, and you're expected to now adhere to the provisions of the Data Protection Act.
Thank you very much. So there is another question here. Just, I'm not really sure I get the intent of this question.
I'll just pick on it real quick. I think what the person is saying is that awareness needs to go beyond the traditional way it's being done. That women, if that also means placing some responsibility at the doorstep of some of these technology companies. And I think by and large, the problem being complained about has sort of been addressed through design, which you now have the capacity to let people have deal into groups of groups. You only need to enable that settings, for example. I'm not speaking specifically about any products, but many of the chat tools that we have, there are capabilities embedded in them where you can choose. You can literally choose if people need to, you need to approve if you can be added to any group, for example. But they're also lower quality problems. I won't say maybe not necessarily lower quality, but they're also like very unpopular problems that I think of course, there's a big place for the regulators to do their bit, but there's also a big place for user responsibility and also user being aware about how technology impacts them. But more importantly, also the service providers being able to honor their own obligations. But then service providers can honor the obligations, give you tools that can also make you safer. It's your job then to also then know how to use these tools to also make you safer. I hate to say it, but you can outsource that responsibility. So, I mean, to that extent, I think that's a big conversation. I think that's sort of like speaks to some of these things. I mean, if you're using tools that are not so privacy preserving, there are quite a number of privacy preserving ones that you may want to explore, for example. But then it's an ongoing engagement that needs to happen. Stakeholders, the civil societies, and everybody, bringing light on what people need to know. But we also have a responsibility as users to do our bit.
But also just to add on that, I think just more on the public awareness part of it. I think awareness needs to go obviously beyond people that can access the law. If you can access the law, if it's accessible to you, then obviously we're talking about a small pool. So it needs to go beyond that, because if this is a law that we're saying is for individuals and data subjects and it gives them the power, then the awareness is about how you do a census, knocking on doors in rural areas to actually talk to the people in the rural areas and the clinics that are in the rural areas that can't download it, don't have internet, don't have access to internet and can't download the legislation. That's where awareness, when we talk about awareness, that's what we're talking about, going to these actual people, because it's their rights most of the time that are stampled on, and they don't know that they have the power, and they don't know what resources they have. And how they can challenge and how they can protect their rights. So I think it's just a capacity thing as well, I guess, because we have to then build capacity. Then we have to talk about who's actually going to go out there, which regulator has the capacity to go out there and educate them. But that's another conversation as well.
Oh, wow, it's been an interesting past 1.5 hours listening to you share insights. And like I said at the beginning of this event, that as far as AI governance and data protection goes in Africa, we have the best of the best amongst us today to speak to us on this issue. And I think now I'm excited about 2025. I'm excited to see what happens in 2025. And then when it all happens, expect me your DMs telling you that, yeah, you mentioned this during our event and we see it happening. So yeah, thank you very much for your insights. We really appreciate you. Thank you for sparing your time to do this with us. We appreciate every second that you have spent with us, and I think these are words that we would hold on to in 2025, so that by the end of the year they will come and tell you that you said this in 2020. Perhaps you are the prophets of data protection that we would have to hold on to in Africa. So yeah, thank you very much. We also want to take our time to appreciate our partners. Dorcas mentioned them at the start of the event. So just to reiterate that this event is Tech Hype spearheaded this event, and then we did it in collaboration with the Tanzania Privacy Professional Association, Privacy Lens Africa, Africa Privacy and Legal LLP, and Data Privacy and Governance Society of Kenya. You would agree with me that we had a very short time to spend with our speakers today, but we do hope that you are very interested in their work, and we have shared their LinkedIn and their LinkedIn profile in the chat box, so you can click the chat box and you can click the link in the chat box and follow them across. But trust me, they are very exceptional individuals and they share insights every now and then. So if you want to know what's really happening in the data protection and AI governance space in Africa, these are people that you really should follow across all platforms. So thank you very much to everyone that attended. Thank you for listening to us. Thank you for making our time to be a part of our event. And so we have come to the end of today's event, and once again we appreciate everybody that has been a part of this. Don't forget to follow our speakers on their social media platforms, on LinkedIn specifically. That's where you really hear that's where you get the juice of the things that they are doing. For instance, read one post articles every now and then, because he's very intelligent, and he just dispenses it like that. Sherry and Libogam, so they just dispense it every now and then, and you want to be the elite bird that catches the worm. So please don't forget to follow them. Thank you very much for joining us. We appreciate you. We've come to the end of the event, so do enjoy the rest of your day. Bye.
Thank you so much. Bye.
Bye.